So simple.
Right, so that's the hardest part about it, you know, being able to do that in half an hour. Half an hour, I mean, yeah, well, 10 minutes.
So we are on remedy section 3. We're dealing with business relationships, and we're in the middle of Anthony's Pier 4 when we last left it. But I want to look at Rule 4 or point out some things about Rule 4, which is the service of process rule. And I'm going to use the federal court Rule 4. Very similar to Massachusetts Rule 4, but depending on what jurisdiction you're in, obviously you'd have to comply in what court you're in with their local service of process rules in order to make sure that the defendant has the required notice. In the event they do not have the required notice or you don't serve them properly in time, then you risk that the matter could be dismissed. As I said to you last time, when an action is commenced, you file the complaint with the court for a relatively modest additional fee. You obtain a summons, and you complete the summons, and then the summons and complaint is served upon the defendant. If you looked at Rule 4, it tells you everything that has to be on that summons. And the idea is that when the defendant then has the summons and complaint, they can see what the cause of action is about. They can look at the summons to determine what court they're in, what the docket number is, what will happen if they don't respond and the like. And that when that is served upon them, the clock starts running with respect to the time they have to actually do something in response to that complaint. Rule 4 talks about who is authorized to make that service, if they chose to waive the formal service of process, how that works. Rule 4 talks about what you would do if the person was a minor or an incompetent person that you're suing. It talks about specifically what happens if it's a corporation, a partnership, or an association, because depending on the defendant's formation, what it is, what type of legal entity they are, different methods of service are required. Rule 4 also specifically talks about if you're suing an agency of the government, what you must do in order to comply with proper service at that point. And as well as not just our own government, but serving foreign governments or state and local governments are all within Rule 4 as well. And then when service is made, what has to happen is that summons has to have the serving officers attestation on it that in fact that they have served the defendant in some way and described the way in which they've been served. Your obligation then when you get that back, because you get the original summons back from the serving authority, that has to be filed in court so that the clerk can enter it on the docket, and so that when entered on the docket, we know that the defendant has to file a response or they risk being defaulted and the like. So the last step in this whole process is once you have gotten the summons back with the bill, then what you have to do is make sure that that's filed in court. And as I said to you last time, most documents in federal court are now filed electronically. So you've got to have some primitive skills with respect to the use of the computer and filing papers. There's actually a little tutorial if you wanted to look at it online in the First Circuit here, Federal District Court of Mass. That's a relatively simple process that you can file those papers electronically. So they give you a little lesson plan in how to do that as well. But most papers now are in fact filed electronically. Some states do that as well, but we are way behind the 8 ball on that in Massachusetts. Connecticut, everything is filed electronically as well. But the Rule 4 requires that at some point that service of process be returned to the court. You know, there are, and if you looked at your rule book, you would see There are provisions within the rule for waiver of service of process, and in essence, accepting the service so that you don't have the expense or potentially the inconvenience of having to send someone out to serve the defendant. And they may want to avoid the embarrassment of it, especially if it's going to be somewhere other than their home and the like. The problem with relying on that type of service is that then to some extent the defendant controls when they send that back to you and when they're saying that they've been served. And so unless you have a really good relationship and you can count on that in essence being returned to you relatively quickly, a lot of times we still start out by serving the defendant in one of the traditional ways, depending on the type of entity they are. And all of our timelines start from the time when the defendant is actually served. So Rule 4 becomes vitally important to kick off the event. You're then going to find that the tracking orders where they say, okay, let's have a pretrial conference, the discovery will take place in this period of time, dispositive motions during this period of time, and ultimately trial in this period of time. A lot of that runs from the filing date or the service of process date. So that all becomes very important to move it faster rather than slower as you start out. Especially the fact is that there is a risk that if you don't pursue your action quickly, that and effectuate service promptly, that you could potentially risk having that action dismissed. Questions on Rule 4? I mean, it's pretty straightforward. It depends on the type of action you filed, and it depends on what court you're in. But oftentimes, it starts with analysis of how does Rule 4 say that this service of process has to be made. And hopefully, usually, it isn't a significant hurdle. There are times where it's inconvenient and you've got people trying to play little games on it, but it shouldn't be a significant barrier to moving forward. When I left you the last time, I asked you about this note on page 462, which says that on the same day these dueling lawsuits were filed over the Fan Pier project, Anthony's conveyed record title in Fan Pier to a trust that his lawyers, you, set up. And it said Anthony's 4 sons are the trustees of the Fan Yards Nominee Trust, Channel Parking and Development. And so what you did is you set up a shell to move the very valuable property into it to make it a little harder to access in the event that they lost the suit, or just to make it harder for creditors and others to get access to it. And so my first question to you is, so would you have done this as well? No? Is something wrong with this? I mean, if a doctor came to you in advance, a doctor came to you and said, I'm thinking maybe I should set up a corporation to insulate myself from a little bit of liability. Wouldn't you do that? Wouldn't you tell them that that's probably a wise thing to do? And I guess I'm wondering how that is different than, okay, we're going to war. Well, we've got to make sure that we're ready to do battle, and we've got less at risk than otherwise. I mean, isn't that preventive legal medicine, or is this too late for that?
I think it's unethical because it's too late.
Well, why is it unethical? I mean, you're the one that decided to explore the little loophole here. I guess I'm wondering why in for a penny, in for a penny, in for a pound. What the hell? Now you've got scruples? And I'm wondering why you think the court put this footnote here, because it does make you look a little sleazy, doesn't it? It makes you look like you were thinking that something was going to go wrong here, so maybe I've got to do a little shenanigans. And I think the court took it that way, because why do we have this big footnote about your transferring those assets into a trust just before all hell breaks loose?
Is that
Huh?
Is that all it is, though? It's just a little sleazy?
Well, you mean it's a little sleazy, but not necessarily violating any codes of ethics or anything like that. Is that right?
Yeah.
Well, what do you think? I mean, it doesn't say that it's in breach of any code of ethics or anything else. I mean, well, it does say that it doesn't look good. But by the way, then, so I'm going to war, and that's what's gonna happen here, clearly. But so I'm going to war, and I'm supposed to leave my flank exposed? I thought this is gonna be what we call a scorched earth legal battle, that as long as the law permits it, as long as it's legal, I'm in. And so this is just prudent lawyering trying to preserve assets and set up yet another little barrier for the other side, before the other side can get access to incredibly valuable real estate. So why shouldn't I? No, and I'm wondering, I mean, you've decided to explore that loophole about there should have been a writing signing off on the project, and we all agree there's no writing. We're going to get to what there is, but he never formally gave them the writing that the other side's lawyers put in the contract that was required. So my job isn't to do the other lawyer's job. My job is to protect my client. And so in that process, I'm going to be a little sleazy because it's okay. And that's what I'm asking you. Is it? Because I wonder if, well, let's say it is okay, because they don't say it isn't. But do you think by doing that, they prejudice the court against their bona fides here?
Probably.
So so even if the law permits it, is it a good move? Or what the hell, if I don't do it, potentially, he's going to say later on, why didn't we make it a little more difficult to reach these assets?
I think it's good lawyering.
It is.
Whether it's morally right or wrong, I think that's besides the point.
Just about money at this point.
Yeah, at this point it's about money, and that's good lawyering on the lawyer's part. I mean, I don't see nothing wrong with it. From what I remember about ethics, I don't think there's nothing ethically wrong with it. Now, morally, can he sleep? I'm sure he will with $700 and whatever he's getting paid.
Is it easier in some of these, like these business disputes and the rest, where it is just about money and all the rest, that it's not, it's not a moral issue. It's not that are these kids going to go home to a safe house tonight, or is this criminal going to get back out and recommit crimes? I mean, it's about money. Who cares at the end of the day? Is that easier then? I mean, there's no moral dilemmas about right or wrong here, because you're representing a guy who's just greedy, or who is greedy, right? Well, we won't say just, but I think we'd all agree he's greedy. He wants a better business deal, which who doesn't want a better business deal to the extent they can? Does sound a little piggish when he says, I'd rather look out over nothing than a lousy $750,000 every year. I mean, the bad testimony. But if I'm going to represent him, then I guess I've got to do whatever I can to try and protect his interests, regardless of what it might make you look like.
I feel like this is just one of those situations where it's almost like we're not even lawyers, we're fixers. So if there's a problem that's going to come up down the road, we're expected to prevent that problem.
Well, and as a general matter, you are, aren't you? I mean, like, if an individual came and said, I want a corporation, why do you want it? Well, because someone said it reduces my liability and potential exposure, which is true, you'd do that. Right? You'd get paid to do it, you'd do it because preventive legal medicine is a good thing, as a general matter. If someone came to you and said, I would like my house in trust, because I don't want potential creditors to be able to seize it that easily. You do that. For individuals, you put a homestead on their property if they needed it. That's the types of things we do. So why is this so out of the ordinary? Is it because, well, you know that it's not just that litigation it might happen. It's that it's happening today.
Well, I think that's the whole problem, the premise of why he even engaged with the lawyer. That's the whole issue right there, is that he's engaging to pretty much, breach his contract and to go forth with protection of his own assets, and not really having to care about the other side and what's going on. So, I mean, the whole premise of how this all started is the problem, morally speaking, but I don't think it's any different from a doctor coming into your office and say, hey, I want to set up, this LLC and then this PLLC to protect my name from, potential malpractice.
I mean, that's, at least it seems like a fair analogy here, as we look at it, that we're asked to do things at times to try and prevent significant exposure. That's what they hope they'll be able to do in a lot of cases. You said that he's in breach of the contract. Is he? Because as the way it read, the contract specifically required him to sign off on the plan in writing, right? And I don't think there's any dispute that he never signed off on the design in writing. Now, there are other factors here that indicates he gave his approval. But the contract, which says he should have signed off in writing.
So there's no contract.
Well, there's no compliance with the contract. So, I mean, I assume that's why you feel comfortable going forward, is that he at least has a legal argument that there is a technical, like we saw in the Weinberger case, there's at least a technical violation of the contract because he never signed off in writing. Well, let's get to some of the stuff that's going on here, because there's a bunch of things that are important to note about the case. And that's what it says. When HBC representatives called Athanas a few days later, Athanas told them that HBC had, quote, a moral obligation. He's now going to preach to them about morals and appropriate behavior, which is interesting. And that they had plenty of room in their deal to pay him more money. It's all about money, right? Let's call it what it is. This isn't about he doesn't like the design. This is about money. And that's what he says. I'd rather look out my window on nothing than on a lousy deal. So it's not about design, it's about money. But there is a provision in the contract that says he should have signed off on the design in writing to express his approval. And meanwhile, HBC is trying to get all these approvals and everything else, which, as you might guess, in a city like Boston is incredibly difficult to get, and time-consuming and expensive and everything else. And then it says, but then ultimately what happens, same day, HBC and Anthony's brought suit against each other. HBC sought declaratory relief and damages for breach of contract and breach of implied covenant of good faith and fair dealing, as well as restitution, specific performance, and 93A damages. So let me ask you about a couple traditional equitable remedies that they're seeking here. One of them is declaratory relief and the other is specific performance. So what's declaratory relief?
The judge gives judgment, is that correct? Well,
Judge gives a judgment. I mean, it's correct. And
judge reviews all the facts and gives an appropriate judgment of relief, the compensatory relief.
Not compensatory, appropriate judgment of relief?
It goes to the rights and obligations of who, whose rights are within that contract, who's obligated to perform when.
Closer. Declaratory judgment is where you seek a decision of the court to a real or threatened controversy, where the court will declare what the rights and obligations of the parties are. Right? So, and that's what we've got here, is we've got a significant contractual dispute. And HBC wants to know, well, Judge, you decide what the rights and obligations of the parties are and interpret the contract. We want a declaration, in essence, of what the rights and obligations are pursuant to the agreement that we've got. Declaratory relief is a traditional equitable remedy. One thing that means, like all equitable remedies, no right to a jury trial. So this would be a judge-made relief alone. It also asks for specific performance. What is specific performance?
In order to do something or desist from doing something.
Well, specific performance normally is going to be in order to comply with the terms of the contract, right? You're asking that the contract be ordered to be performed according to its terms. Again, another traditional equitable remedy where the court will determine what the order will be consistent with its interpretation of the terms of the contract. You're asking that the contract terms be specifically enforced. 93A damages we talked about, that, and so specific performance, no right to a jury trial. As I told you last time, 93A claims no right to a jury trial because it's a statutory remedy. And then it talks about, one of the other counts is restitution, but we'll come back to that at some point. So they've got this multi-count complaint, and that was HBC's. And then Anthony's, if you go on, said basically they also sought declaratory relief, which we just talked about. Damages for breach of the contractual duty to proceed expeditiously, and they say they think HBC breached the covenant of good faith and fair dealing. Anthony's also wanted 93A damages. You know, the best defense is a good offense. So we've got both of them claiming to be injured as a result of the other's actions, both of them seeking damages, and both of them ready to bring out the flamethrowers and go scorched earth on the case. Not uncommon in cases of this magnitude, but if you think about how much attorney's fees was likely spent on this, it's kind of astonishing, but it's not when you think about what was likely at stake. It says the trial was bifurcated. What's that mean?
Divided into two parts.
What are the two parts?
The sentencing and the...
Not sentencing, these are civil cases now.
It's the trial part where they determine who is at fault, and then
What do we call that as lawyers?
the trial.
Trial, where we determine who is at fault. What's that called?
Proceeding.
It's right here on page 463. What's it called? For a civil suit. Liability, right? And the second phase of the trial would likely be damages, or in this case it could be relief, but that's what it says. The trial was bifurcated into phases on liability first and then damages. Let me talk a little bit about bifurcation of trials. As a general matter, if you are the plaintiff, you do not want the matter bifurcated. Because it's not in your advantage, because you have to win twice then, right? First, I've got to say that I've got to be able to establish separately that there's liability, and then, and here's the other hurdle, with or without the same jury. So we'll talk about that just quickly. I then have to establish my entitlement to damages. If it's a separate jury, then I've got to educate them all over from the beginning. And sometimes the court won't do it back to back. Some of the intellectual property cases you see, they have a liability phase, they discharge that jury, 6 months, 9 months, whatever, we come back for damages. That means I've got to re-educate the whole jury about what happened here. And a lot of times, issues of evidence of damage and liability overlap. And so, to the extent you're the plaintiff, this makes it much harder to convince the jury that you're right, or juries that you're right. It also takes away what I think a lot of juries do, which, you know, the phrase people use to describe, it's a horrible phrase, but right, split the baby in half. You know, I'm not sure they've got a great case on liability. They want $10 million in damage. What do you say we give them 5? Right? Send them on their way. So it's sort of a compromise verdict. And if liability and damages are in the same case, then they can do that. But if they're split to a bifurcated case, then first we're going to have a separate vote on liability, and then we'll come back and hear the damage issue. That makes the plaintiff's job that much harder. If you're the defendant, that's ideal. I got 2 separate bites at it, 2 cracks to beat you. I'd love to have it bifurcated. Even better if I can bifurcate it with 2 separate jurors. Because if the first one comes back on liability, I'd rather get rid of them. and then start anew. And there is some argument constitutionally that there is law out there that is not, that the plaintiff can use to try and argue against the bifurcation. So you really want to be careful with this as the plaintiff's lawyer, because a lot of defendants in bigger trials, longer trials, will argue for it and try that because it gives them an extra bite at the apple. The defendants are smart enough to argue bifurcate it and we'll see what happens, because, and another one of your arguments should be in opposing it, because the theory is it saves trial time, right? It's going to be, if there's no liability, we don't even have to worry about all that other evidence on damages. So judge, it'll be shorter for you to do it this way. What you have to argue is it's not going to shorten anything, because the liability and damage, a lot of that evidence overlaps. It actually might make it twice as long or significantly longer, because we'll have a lot of redundancy as we introduce the evidence. Some of the evidence will be relevant both to liability and damage, so we'll have to do it twice. Let's try it all at once, be done with it, submit it to the jury, and get a decision. This is a very real problem as you start to think about trying cases, especially if the case is of any monetary value, because it appeals to judges practically, because it might shorten the time you're in my courtroom. And it's an argument defendants love to make, because it gives them two completely separate cracks at it. It's a real problem, and I've seen it and argued against it a lot. You just have to be prepared for it. Here, you've got a relatively complex contractual matter and a significant amount of time that's going to be devoted to liability alone. So here they do decide to bifurcate it. As a plaintiff, to me, you never want to bifurcate it. So you want to oppose it to the extent you can. So let's talk about the evidence of the development itself, because what it says is, in the Phase 1 trial, the judge ruled that Anthony's purported disapproval of HBC's development plan was a breach of both the express terms of the agreement and the implied covenant of good faith and fair dealing. The HBC had proceeded expeditiously, and they had not breached their covenant of good faith and fair dealing. At the conclusion of Phase 2, so then we went on with a separate trial for the damages. But again, this was jury waived trial, to the extent any of these claims could go to a jury. And so we didn't have to worry about impaneling a separate jury, and we didn't have to worry about re-educating the court, because it's the same judge hearing the case. I still would have asked to do it all at once, but I can understand with non-juries why it has more attraction to it. At any rate, it says the judge awarded HBC expectancy damages for breach of the agreements and the alternative reliance damages, plus other amounts, blah, 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 blah. And so Anthony's now wants to argue that he doesn't like the judgment's inappropriate and all the rest. So let me ask you, it says expectancy damages and in the alternative reliance damages. How do I, what's the difference? How do I calculate expectancy, and how do I calculate reliance damages? Because I want you to look at, where is it? Hold on. Well, it's way at the back on page 478. It says damage issues. The judge awarded HBC $42.6 million in expectancy damages. If you have a different page of the case, it's bottom of 170. In the alternative, judge ruled HBC is entitled to $14.5 million in reliance damages. So I guess I'm wondering, what's the difference, and how do we define expectancy versus reliance damages? Because I want to point out very clearly to you here these are vastly different amounts, right? There's a difference of $30 million between the two measures of damages. Now, if you represent HPC, which one do you want? You want the 42 million or you want the 14 and a half? You obviously want the 42. So this is important as you think about practicing law to recognize that depending on what you plead and then what you offer proof of, you have different measures of damages even for the very same loss. So what is expectancy damages? How would you define that? Expectancy damages are designed to do what? Go ahead.
Put the non-breaching party in the position he or she would have been in had the contract been performed. Had been fully performed.
And therefore, they would be entitled to get what?
What they would have if the contract was.
What the profits would have been in essence, right? What they would have expected to receive had the contract been fully performed as it should have been, right? And so that's what they're saying is had it been done here, if there had been no breach, HBC expected to receive as profits $42.6 million expectancy damages. So if the contract likely would have resulted in a significant profit, then you want to pursue expectancy damages. By the way, in your complaint, you'd ask for one or the other. You don't have to make a decision until the jury comes back with the numbers. Right? You're not going to get all of this. You're going to get one or the other, but obviously you're going to pick the higher one. What you got to remember is as you start to both plead and ultimately pursue through the course of discovery and offer evidence at trial, you want to recognize that there's different measures of damages even for the very same wrong. So what's reliance damages then? So if expectancy damages, as Marissa said, are designed to put you back in the position you would have been had there been no breach of the contract and it had been fully performed, what do reliance damages are they designed to do? Go ahead.
It's the measure of the compensation that you should get based on how much you relied on that, the economic harm that you suffered from relying on this contract being fulfilled.
I think we can do better than that. Go ahead.
To put the non-breaching party in the position they would have been in if the promise was never made.
If the contract had never been entered into, right? One of which is, if you think about the right expectancy, if the contract had never been breached, this is what I would have likely recovered in expectancy. And the second, reliance damages, is if the contract had never been entered into, I wouldn't have lost these types of funds. So one is going to give you what you've expended in reliance on the contract having been entered into, which now will never be performed because there's a breach. And the other gives you what you would have been expecting to obtain had there been no breach of the contract. One gives you, the reliance gives you, had there been no contract, you wouldn't have spent all of this money. The other gives you, had there been no breach, right? What I expected to obtain if the contract had been performed as compared to what I expended in reliance on the contract having been entered into. And here, as you can see, it's a very different amount, but this is not unusual that there are different ways to measure what those damages are. Part of it means you have to start to think about what proof would I introduce on this issue. So let me just ask you that quickly. What proof would you introduce that the reliance damages were $14.5 million? From an evidentiary standpoint, what are you going to offer at trial?
Contract.
Well, okay, you got to offer the contract in either case in all likelihood, but what else what are you going to offer to prove the damage part of it?
Money you spent, the receipts.
Yeah, right. What do you got? What do you got? Lawyers' bills, engineering bills. What do you got? What did you spend to try and make this contract to go? And so your evidence will be your lawyer's bills, your engineering bills, your time that you've spent with, as long as you can monetize it, what it is you've lost that in essence you're trying to claim you're out of pocket as a result of having entered into this contract that won't be performed. And that's just the evidence. Here it's a big number, but in a lot of it may be lawyers' fees, a lot of it's probably permit fees, a lot of it's engineering fees. Some of it will be the loans you've probably taken on the money that you were either advanced or used as a result of the process. I mean, there's a lot, obviously with numbers that big, there's a lot of items that probably likely go into it. Also, interest becomes a factor, as you can see in the footnote, but that becomes after the court issues the judgment. And some of these cases that take a long time like this, you're looking at pretty significant amounts of interest that can be added to that judgment at a pretty good rate. Let me go back to the top of 161, page 464 in the original decision. The court tried, as many courts will do, to try and mediate the dispute. It's not uncommon that as you get closer to trial, and especially a trial that took this long, that the court would sit down and say, well, where are you at? How far apart are you? You know, try to, what we call, bang heads a little bit to see if you can move the parties to a place without having to invest all the time and expense of a trial that no one's going to be satisfied with. Anthony then complains that that is improper because I think because he didn't like the result, that they weren't able to mediate it, and now he lost the trial. But the fact is, a lot of times the judges will try to have serious conversations with the lawyers about settlement possibilities, and it's just, he's just looking for anything at this point to complain about because he doesn't like the judge's decision. And as I've said to you here, this is the judge's decision. This is only the judge. There's no other jury. There's no jury. There's nothing else. It's the judge. Now, there's findings of fact and conclusions of law that are problematic as well. So, as he sees it. And by the way, it says, I knew it was here somewhere. It says 79 days of trial, including over 1,000 findings of fact and 35 rulings of law, together occupying 445 pages. So 79 trial days, 5 days a week, 16 weeks, 4 months. The cha-ching, 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 that is the trial that this took place. What are findings of fact and conclusions of law, and when are they used? Because it says, this was on page 465, because there's all this issue about, well, where did these findings of fact come from? Anthony's is saying, well, you adopted almost all of theirs. What is that? What are findings of fact and conclusions of law? Because we're going to see it a lot here, and it's one of the weeks we actually will look at it even separately. What are they? What rule governs them? Did anyone know? When are they used? I'll take any help. Maybe I should help you then. Rule 52. Okay, Rule 52, findings of fact and conclusions of law. Anytime that there's a non-jury trial, so that the judge has to issue the decision, then the court must make what we call findings of fact and conclusions of law. The reason that Rule 52 requires that is that we want the court to set out separately its basis for its decision. The idea is that you can then look at it and see that it's well-reasoned and appropriate, and that the court applied the correct law. So where do those findings of fact come from? Well, they come from the evidence introduced at trial. Okay? They come from the parties' stipulations, if they've stipulated to facts as well. But they come from the evidence that's received through the course of that trial. A lot of times, almost always, the court will ask you as the lawyers to submit what we call proposed findings of fact and conclusions of law. A lot of times, obviously, that's going to be based on the trial transcripts and like, because you got to show that the evidence was actually received. In an 80-day trial, this is a ton of work, because you've got to go through the transcripts now, and you've got to be able to make a specific reference to when that evidence came in and what it actually proved, right? So if it's a Jeeves said that, you know, I don't want to look out over, I'd rather look out over nothing than a lousy 750 grand, I got to make a reference to where in the transcript or where in the documents, where in the evidence that came in, and put that in my proposed findings of fact and conclusions of law. You have an ability then, by preparing those findings of fact and conclusions of law for the court, to create a more bulletproof result for your client. And so oftentimes the court will ask us to submit those first, and then they will, from those, create their own, sort of. So that's what they should do, because if I just take all of Jeeves' proposed findings of fact, and all of his conclusions of law, and don't accept any of you guys, then it looks like I'm not doing an independent analysis of the evidence or the law. I'm just adopting his findings verbatim. And that's in part what Anthony's complaining about here. You know, the better practice, especially now, this is many years ago, but we cut and paste them, right? I'll take a couple of arrays, and even if I'm going to use most of Jeeves, it looks like there's more of an independent process there. And it's frankly a lot better for the case on appeal if the court doesn't simply adopt one side versus the other. But here's the other problem, and I think it's with Anthony's case, is he's lost a lot of credibility here, right? I'm not sure what his proposed findings of fact and conclusions of law look like, but at some point the court may well feel that one side shooting straight with them and the other side is not, and so they can't be trusted, nor are their findings of fact appropriate, or the law they want me to use isn't appropriate. And so I can see how this happens. I think the better practice is when you make those findings of fact that it appears that there's more independent judgment going into that. And that's really what he's complaining about. But I think over the course of those 80 trial days, he has long since lost the court's sympathy, and they're not going to cut him any slack, certainly not when you think about them providing a judgment to HBC for about $50 million. And so they go through some of this for some period of time with respect to the findings of fact and the like. At some point found that it was appropriate for these findings of fact. The court appears to have used its authority correctly and really used its decision making to look at those. Anthony wants to argue, top of page 166. So as well paid as these lawyers are, as famous as some of them are, it says here that they didn't plead waiver as an affirmative defense. What happens if you don't plead an affirmative defense?
You lose it.
You lose it, right? No matter how famous or rich or everything else you may be. And that's just what they say here. You can't raise issues for the first time on appeal. This is 166, page 471 in the actual decision, and expect then that the court is going to save your butt as well. It's just not the way it works. And so it says here, generally a failure to plead an affirmative defense results in the waiver of that defense and exclusion from the case. You guys know that. And the fact is that arguing issues raised for the first time on appeal is a recipe for disaster. And that's what happens here. And then they go into this implied covenant of good faith and fair dealing. And so there's language right at the start of this on page 471. It says, every contract in Massachusetts, implies good faith and fair dealing between the parties to it. I want you to look at the bottom of 473, 167, if you've got a different pagination. You decided, on behalf of your buddy Anthony, I guess in for a penny, in for a bunch of pounds, Anthony asks us to hold that in contracts between sophisticated business people, no covenant of good faith and fair dealing is implied. This is your next strategy now, after everything you've done, that now you're going to say, well, listen, we can get around in the mud and roll with each other because we're sophisticated business people. You can't expect us to act with each other in good faith and fair dealing. What does the Supreme Judicial Court say about that? We decline so to hold. Anthony cites no authority. So it's not even just that. You don't even have any authority to support the contention. And then they go on to say, indeed, the rule is clear in Massachusetts. Every contract is subject to an implied covenant of good faith and fair dealing, which obviously should make sense to you. I mean, at some point, you got to stop making arguments that just have no merit to them whatsoever. You're going to have to live for another day and maybe back before the Superior Court or the Supreme Court at some point. This is just you're now making arguments like this are likely going to cost you costs on appeal, because you better have some support for it. You don't have any. And what they do say, though, and the law has changed a little bit in here, but the basic principle is still the same. Anthony makes an argument that among two business people, you can expect that the combat will be a little rougher, and it should be a little more acceptable as opposed to when it's a business and a consumer. And the court agrees with that basic proposition. Something that is unfair, an unfair trade practice, as when practiced against a consumer, may likely not necessarily be an unfair business practice when it's two businesses competing for the same business and the like. And so the basic premise that yes, it may take a greater level of unfairness when we're going to penalize a business under 93A when they act with another business as opposed to a consumer, because you guys aren't competing. Consumers aren't competing, they're looking for those services. So to some extent, that the point is well taken, but the problem here is he is way outside what is permissible here. He's greedy, he had a technical argument about the breach, but the fact is he had expressed his approval of that design orally many occasions. In fact, one of the pieces he was recorded on the video saying that he thinks it's one of the grandest things that's ever going to take place. And that's something that you probably should have known about, looked at when you were doing your Rule 11, right? Well, okay, I got that. I get what you're saying. There's no writing. What do they have? What is out there where you've expressed a desire that you think that this is a good plan and a good product and you're happy to have it on your land? Fact is that I think you probably should have done a little more investigation at the outset trying to educate him about the problems potentially with this suit, including, I hope you wrote him a letter at the outset saying, you know, this has some significant risks with it because these numbers are astronomical, right? Back then, 50 million today is a lot of money, right? I mean, that's bet the company money. And look at the interest alone, $3 million on interest. Jeez. Right? I hope you got a letter in your files because you don't possibly have enough malpractice insurance to cover that when he comes after you. And he's going to come after you. Right? I mean, a guy like this doesn't walk away from the fight. And I've seen that before. The lawyer, you know, the client comes back later on and says to the lawyer, you should have told me what a bad suit I had. Why should they have? I was telling you should have listened to me. I told you that you ought to be settled in this, so you shouldn't be bringing it. But you and your lawyer wanted to continue to pursue it. And then I've seen them. Then I get a kick out of that. So then those two are fighting. Good for them. Good for them. You have pox on both of you. You shouldn't have cost any of us all this money all along. Anthony says, let's just take a look at the damages now. A couple things about the damages. He's trying to argue that they're too speculative. Listen, anytime we have to try to value lost profits, there's obviously some uncertainty about it. But just because there's some uncertainty doesn't mean I'm not entitled to collect it. Right? Civil standard of proof. More likely than not, this is what would have happened had the contract been performed. He's got an ability to be able to offer evidence on that. So someone, real estate appraisers, someone's going to have to come in and tell us what the value of the improvements would have been, what the rents would have been over time, what the income would be. But we value children's lost lives. We value all sorts of things all the time. And there's some uncertainty to it that doesn't mean that it's speculative. It says here, the aim of measuring damages, 479, in the event of a breach is to place the injured party in as good a position as he would have been had the contract been performed. That's precisely what the measure of the expectancy damages are here. You did have expert testimony on the value of the property and what would be likely looked at here. If I asked you what makes someone an expert, you'd be able to tell me from an evidentiary standpoint.
Experience
Beat.
or education.
To ease. Go ahead.
Training.
Okay, but wait a minute. You can-
Background, experience, expertise, and training, or education and training.
Right, beat. What makes an expert is beat, right? Background, education, experience, and training. And so with respect to the experts here, it's not uncommon when we're trying to value real estate or the rental income from property or the economic loss because of something like this. We're going to call a real estate appraiser. We're going to certify them according to their beat, background, education, experience, and training. And then they're going to be able to provide their opinion, because that's what it is, as to what the value of the properties are and what would have been likely what we were looking at here. And valuation, obviously, especially a future valuation, is subject to some speculation, especially in a situation like this, where we don't know the world that would have existed, but we do that all the time. It's not uncommon. The fact that it's difficult to measure doesn't mean you can't do it to the satisfaction of the trier of fact. It says here, at the conclusion of Phase 1 trial on liability, the judge issued an interlocutory order enjoining Anthony's and the Fanyard parties, among others, from conveying, leasing, or otherwise alienating the fan pier property. Just before the Phase 2 trial on damages began, HBC sought to raise the issue of the validity of the conveyance of the fan pier property to the fan pier Yards Nominee Trust. What they were trying to do, what they were going to argue, and that's why the court issued the injunction, is to argue that that was a transfer and fraud of creditors. And that likely was, right? When you can show that, if you can show that the person is either insolvent at the time they make the transfer, will be insolvent, and the purpose in part is to do it to make that transfer so that you're defrauding creditors, then the court has the power ultimately to go back in and set aside that conveyance because it's considered a transfer and fraud of creditors. And so what the court did here is just issue the injunction preventing them from transferring it any further because, as the court said, well, we don't know whether there's damage yet, but if there is, then we'll have to go back in and fix that as well and ultimately transfer the property back as they have the ability to, if they determine that the transfer was improper, as they will ultimately here, because the property is the key to the transaction and all the damages. So a judgment like this must have broken Anthony. Yeah? Yeah, you'd think so, wouldn't you?
I think so.
But I told you at the outset this story that he had a lot of powerful political friends and influences. So what's on Fanpare now? What happened to the site? If you don't know, I'm going to help you. What's there now, well, luckily, as I told you, Anthony has very powerful political friends, including congresspeople, mayors, you name it, run up the ladder. His friends, through our tax dollars, bailed him out. The federal courthouse now sits on this land, the Joseph Moakley Courthouse, who used to be the congressman from that area.
Really?
Yep. It's a beautiful courthouse, gorgeous. Most of us would have lost everything we had and would be lucky if we could get a bed at night at the Pine Street Inn. He landed on his feet because that's the way life is for some. And they bailed him out because they shouldn't have been bailed out, because what he did was really, really wrong. But he had a lot of people that I guess owed him as well, and he called some of these favors in, and as it turns out, even as bad as these numbers are, he more than landed on his feet, partly because others abused the process on his behalf. And as you all know, the seaport now is awash in money. But part of it started really from when that federal courthouse was built. So Anthony's helped trigger all of that. So the rich and powerful stay rich and powerful at our expense. So it's a gorgeous courthouse if you haven't been there. But you would have thought, from reading the case, at the end of this would have a different result. It turned out it's an age-old story that 50 million is a drop in the bucket by the time we're done. So it's a little disappointing, because as you read from the case, he should have been punished because it was greed. So you wrote him a letter at the outset telling him this was a bad bet, right? You didn't just take that pile of money across the table and not put a little letter out to him saying, listen, this could go bad, because this went real bad, right? 50 million bucks.
You always need a CYA letter.
So you did that. You told him, you cautioned him against this. You said this might not be the best idea in the world. You cautioned us against this despite taking all his money.
I don't know if they did in this case.
No, I'm asking you. This is it. We don't care what they did.
No.
I want to know what you're going to do when a year from now you're out there practicing law.
Definitely.
Ethically speaking, is it okay to take the money, put it into your IOTA account, then write the letter?
See, that's the problem. That's the problem, Ray. That is the problem. Oh, I got the money. Now let me tell you, now that I got your money, this could go bad. But I'm signing up for the cruise. I don't know. It troubles me because listen, when he does sue you, he's got the first letter A is what you thought was your CYA letter saying you said it was bad, but you still took his money and went forward. You got to have the letter because people forget that you told them all these bad things. But you do need people to understand that there's a serious risk in situations like this, because he could be and he was ultimately perceived. I think in part it was because of who he is, his access to power. He is incredibly influential in Boston at one point. When I was sworn in '83, that's what my brother took us down. We went down there for lunch. It was beautiful. I mean, it's great. It was always a beautiful place. And a lot of political fundraisers. I mean, he was so connected. It's just, and the Pritzker family's from Chicago. I mean, there's a lot of angles to it. So who the hell cares about people from Chicago here, right? I mean, Boston, Chicago, we're better than anyone else. So there's a lot of all of that at stake. And as it turned out, even as the Pritzkers did well, at least financially, from that judgment, he, at the end of the day, sort of, pushed it off his shoulder. It wasn't the end of the world as you'd think. So it's an interesting case. It's a very interesting background to it. Let's look at, you've got one more case here. That it's another poor franchisee that's Well, I think he's a poor franchisee that's gonna take it in the neck before we're done. But I worry more about the little guy than the big guy anyway. But I'm wondering about this Zapata case. Am my sympathies misplaced here? Because sometimes you can't help people who are bent on their own self-destruction, right? Zapata versus Dairy Mart, and again, it raises the question about covenants of good faith and fair dealing and the like. But Dairy Mart has a provision within its franchise agreements that says that they have the right to in essence buy you out, or that they can terminate the franchise when the period is done for that franchise. And there was a provision in this convenience store franchise relationship that Mr. Zapata said he understood, and he did. I mean, it wasn't difficult to understand, that allows either party after 12 months to terminate the agreement without cause on 90 days written notice, right? So there is a very clear provision in there. And in the event Dairy Mart did it without cause, they agreed to repurchase the sellable merchandise at retail prices, full retail prices, less than 20% discount. Mr. Zapata, they explained the provision to him. He understood every word of it. He thought they could only terminate it for cause, but he did understand the language, and you've got the provision in here. So then in November '77, Dairy Mart presented another independent operators agreement to him. Some of the terms were less favorable to the store operator than the earlier ones. He said, well, I'm not going to sign the new agreement. And that's his option. But then Dairy Mart on January 20th, '78 gave written notice to the Zapatas that their contract was being terminated effective 90 days, just as the contract said it could be done. And so what he wants to argue is that those clauses, which are pretty clear on their face, are now unconscionable, and that they shouldn't be enforced because the results will be unfair, that he will lose his store, he will lose everything that he has invested in the store. And Dairy Mart's position is that he declined the opportunity to take the agreement to a lawyer for advice. He had ample opportunity to consider the agreement before they signed it. And while it's unfortunate that he's going to lose the store, that clause was in there, it was clear as to what it meant. And despite the horrible hardship as he now sees it, the contract's the contract, why can't they terminate it according to its own terms? And so that's the question, is that why should Dairy Mart be allowed to terminate the contract in accordance with its own terms that the parties acknowledge they knew about, even if it has an incredibly harsh result on one of the parties? Is there anything that prevents them from anything in the law that prevents them from terminating the agreement according to its own terms that were pretty clear, right? This is not hidden, this is not confusing or dense language.
They told him to talk to the lawyer.
And he said no, right? We as lawyers, it's not our obligation to save people from their own stupid mistakes, even if the results are harsh. And that's, I mean, I do feel bad for him, But as Zach said, he was told to go talk to his lawyer. He was, maybe there was some negotiation. He chose not to sign the other agreement they wanted him to sign. Yes, the terms were different, but they had the right to terminate that agreement within 90 days. You as the lawyer now are just trying to protect Gary Mott's rights that they want. Yes, it may have a very sad result for the Zapatas, but what should prevent them from terminating the agreement according to its own terms? And the answer is nothing, right? It's not unconscionable simply because it works a harsh result, especially as you think about some of these franchise agreements. They're almost never going to favor they don't favor the franchisee. It's not in their business interest to do so. And so they're not going to do it. Zapata's out, even if it has a harsh result. It's nothing unconscionable about terminating the agreement according to its own terms. He's out. He's done. It is what it is. Questions? I'll see you next Tuesday.